Hello and welcome to Compliance Briefs on Client Due Diligence for Trusts, Funds, Partnerships, and Other Legal Arrangements. This is part 3 in our ongoing series on client due diligence, where we explore key obligations and best practices for effective compliance. This compliance brief will outline the key client due diligence (CDD) requirements for a range of legal entities and arrangements, including trusts, funds, partnerships, occupational pension schemes, clubs, societies, charitable foundations, local authorities, and public bodies. It will highlight the specific due diligence measures needed to identify and verify the relevant parties involved, assess the purpose and nature of the business relationship, and ensure compliance with applicable anti-money laundering, counter-terrorist and proliferation financing as well as sanctions regulations. Trusts. When dealing with trusts or other similar legal arrangements, it is essential to identify and verify all natural persons who exercise ultimate control over the structure, by means of ownership or other means, in accordance with the definition of beneficial ownership outlined in the AML law. This includes individuals who hold control either directly or indirectly, such as the settlers, trustee or commissioner, any protectors if appointed, and the beneficiary or beneficiaries. These individuals must be treated as beneficial owners and verified following the procedures described in Compliance Brief on Client Due Diligence Part 2. If the person who will benefit from a legal arrangement or entity are not yet known, the ICPAC member providing services should still know the class of people it is meant to benefit. The firm must then identify the actual beneficiaries when a payment is made or when someone uses their rights as a beneficiary. When a firm receives funds on behalf of a trust, it must first ensure that the source of those funds is clearly identified. It is also important to understand the nature and purpose of the transaction to confirm it aligns with the trust's objectives. Any payments made must strictly follow the terms set out in the trust deed or governing documents. Finally, no disbursement should occur without proper written authorization from the trustee, ensuring accountability and a clear audit trail. Funds. When assessing a fund, it is essential to determine the purpose for which it operates, as this provides context for its activities and helps evaluate potential risks. The firm should verify that the fund has been established for a legitimate and lawful reason. It is also important to confirm whether the fund is regulated within the European Union, outside the European Union, or operates as an unregulated entity. Additionally, the firm must establish whether the fund is subject to supervision for anti-money laundering and terrorist financing purposes, which is a key element in risk assessment. Lastly, identifying the jurisdiction in which the fund is established is crucial, as the regulatory environment and associated obligations vary across different regions. When assessing an EU-regulated fund, the firm should verify both the address and registered address through the relevant regulatory authority. It should also gather sufficient information on all key parties involved, including the fund manager, the beneficial owners, such as holders of management shares, investment managers, advisors, administrators, and, where applicable, the depositary and custodians. If the regulator does not provide adequate information to confirm the integrity and authority of the fund manager, the firm should carry out Know Your Customer and client due diligence procedures on the fund manager. In addition, screening should be performed on all involved parties to manage potential AML, CFT, and sanctions risks. When dealing with a regulated non-European Union fund located in a non-high-risk third country, and where that country applies anti-money laundering and counter-terrorist financing measures equivalent to those required by the European Union Directive, the same due diligence procedures that apply to EU-regulated funds should be followed. In such cases, the firm must also document the steps taken to confirm that the fund qualifies as an obliged entity and that it implements AML, CFT measures and procedures that are equivalent to EU standards. Proper documentation is essential to demonstrate compliance and to support the firm's risk assessment process. When assessing an unregulated EU fund, the firm must evaluate any potential risks related to corruption, bribery, money laundering, or other financial crimes. It should also review its own client acceptance policy to determine whether any internal restrictions apply to entering into such a business relationship. All corporate documentation related to the fund must be obtained, and full Know Your Customer and customer due diligence procedures must be carried out for the holders of management shares, the fund manager, and individuals responsible for governing the fund. Screening should also be conducted for the holders of management shares, the fund manager, the board of directors, and the fund itself. Additionally, the firm should gather sufficient information to understand the fund's control and management structure, including verification of key parties such as investment managers, advisors, administrators, and custodians. Financial statements or other available financial data, such as management accounts, should be reviewed to ensure that fund operations are appropriately controlled and that relevant information can be accessed when required. For unregulated non-EU funds in non-high-risk third countries with equivalent AML/CFT standards, apply the same procedures as for unregulated EU funds. When a fund, whether regulated or unregulated, is based in a high-risk jurisdiction, the firm must apply enhanced due diligence measures. This means going beyond standard procedures and tailoring the due diligence process using a risk-based approach, with particular focus on the riskiest elements of the business relationship. Importantly, before entering into any such relationship, the firm must obtain formal approval from senior management, ensuring that the decision is reviewed and endorsed at the appropriate level of authority. Partnerships. When dealing with clients operating under a partnership agreement, firms may need to adopt a hybrid approach to client due diligence. This is because the partners involved can be either natural persons or legal entities, each requiring a different verification process. Information about these procedures can be found in Part 2 of the Compliance Brief for Client Due Diligence. It's essential that firms gain a clear and comprehensive understanding of how the partnership functions, including the roles and levels of participation of each partner. Particular attention should be given to identifying and verifying any partners who hold significant responsibilities, such as general partners, who may have the authority to manage or represent the partnership. Other legal arrangements. For occupational pension schemes, client due diligence should focus on verifying the identity of the principal employer, as well as the trustees responsible for managing the scheme. The trustees' identities can typically be confirmed by reviewing the scheme's trust documents. It's important to note that there is no requirement to verify the identities of individual beneficiaries who will receive scheme benefits unless the firm intends to provide them with advice on a personal, individual basis. When conducting client due diligence on clubs, societies, or charitable foundations, firms must first understand the purpose behind the entity's operations and ensure that it is operating legally. This includes requesting and reviewing the entity's constitution and the certificate of registration issued by the appropriate government authority. It's also essential to verify the identity of all signatories using the same procedures applied to natural persons. Recent studies have shown that such entities can be exploited by criminals and, more critically, by terrorist financiers. Therefore, firms should apply heightened scrutiny during both CDD and risk assessments, paying close attention to the stated purpose of establishment, the jurisdictions the entity may be exposed to, and any potentially suspicious individuals associated with the organization. When the client is a local authority or another type of public body, the firm must obtain a formal copy of the resolution that authorizes the undertaking of this transaction. This ensures the legitimacy of the engagement and confirms that the public body has properly approved the activity. Additionally, it is important to identify and verify the individuals who are authorized to act on behalf of the authority or public body, following the standard procedures for verifying natural persons. Additional resources on client due diligence are available on the ICPAC website. These include the guide Best Practices for AML/CFT Compliance, which provides an extensive list of due diligence measures a firm may undertake, and the Guidance on KYC Documents, which sets out a non-exhaustive list of documents to be collected by ICPAC members across various jurisdictions. The guidance also offers links to useful resources such as official registrars of companies, beneficial ownership registers, BORIS, for all EU member states, the Public Register of Authentic Identity and Travel Documents Online, PRODO, consolidated sanctions lists, most wanted lists, high-risk jurisdiction watch lists, and information on electronic evidence. Both documents can be found on the ICPAC website under the Monitoring and Compliance tab within the section Compliance Guides. In addition, ICPAC's Monitoring and Compliance team has compiled a set of frequently asked questions, FAQs, which can also be accessed under the Monitoring and Compliance tab within the section FAQ. Part 4 will cover enhanced and simplified due diligence. I hope you found this useful. For any queries, you may contact us at compliance@icpac.org.cy. Thank you and goodbye.